The concept of business prudence ingrained in section 2(1)(f) for international commercial arbitration is again inbuilt and ingrained in section 7. Section 7 neither restricts the term agreement to be one conventional document nor restricts it either document-wise or party-wise. It uses a broad expression defined relationship, whether contractual or not. This is clearly suggestive of the legislative intent that any kind of legal relationship, even if it is not contractual, that is, there is no contract between the entity, I am not using the word party or signatory, between the entity whose actions or participation results in a defined relationship can form the subject matter of an arbitration agreement. That's why this wide definition consciously chosen. 12, my lord, I have already pointed out. 13. Section 7(4) mandates an arbitration agreement to be in writing. The conventional agreement which comes to one's mind, that is a written document describing inter se rights and liabilities between the signatories to the document, bearing the signature of such contracting parties in such agreement, is placed in section 7(4)(a) as a separate and distinct category. Now, next, the said agreement contemplated under 7(4)(a) is, however, not restrictive, but will be guided by 7(1). So, my lord, there can be, my lord, kindly pause here for a minute. There can be an agreement which is under 4(a), document signed by the parties. I'm sorry, 7(4)(a), which is a document signed by the parties, but it will have to be examined under 7(1), because it can be an agreement where it clearly comes out a defined relationship which may not be contractual under this agreement. Lord, I hope, my lord, I am able to make myself clear. My lord, continuously, my lord, I am saying, my lord, in their contract, Mr. Khambata and Mr. Devan's contract, they continuously refer that the goods will be supplied by Mr. Mehta. I am not, my lord, a document signed by the parties. I am not a signatory to that document. But from the document, it emerges that there is a defined legal relationship emerging from that document. Like, for example, there are certain obligations incorporated by reference. They can say, Mr. Khambata can say that I'll supply goods to Mr. Devan, but we have a separate agreement dated so-and-so, registered at so-and-so with Mr. Mehta, and he has agreed thereby that he would supply the similar goods to me, which I will supply to him. So I
may not have bargained for a contractual relationship between you and Mr. Devan, in your example.
Yes.
Unless there is a tacit acceptance by you of the obligation which Mr. Khambata has assumed to supply goods to Mr. Devan, you would not be liable.
No,
merely because, say, suppose, for instance, you are the foreign collaborator of Mr. Khambata's client. All right, that you are the person who has prepared the software, or you have prepared the service agreement, the license agreement. You are the real originator of it all. Unless there is something to indicate that, look, you have assumed the obligation, that you stand behind the obligation which Mr. Khambata has assumed to.
I vouch. Yeah. That is why I emphasize it must emerge a defined legal relationship with respect to the dispute. I'll just give an example, simpler example. Look, Tata Steel is a Tata Group of Companies.
Yes.
Tata Motors is a Tata Group of Companies. Suppose Tata Motors enters into an agreement with me for buying certain products, tires, machinery, etc., etc., and there is a dispute between the two of us. I can't involve Tata Steel saying that it's a group of companies. If he is unable to pay, you pay. But if there is a defined legal relationship with third person, and that is how, my lord, the courts have construed, defined legal relationships are presumed under various doctrines which your lordships have evolved in other jurisdictions also. Back-to-back contract is one such thing. It would be a fact-specific determination.
Right.
There would not be any, my lord, straight jacket answer. But The point I am respectfully urging for your Lordship's consideration is there is no exclusion. In fact, Section 7 incorporates Group of Company Doctrines by not restricting it to mere parties to the agreement, except in 41A, 74A, but it restricts even correspondence. There can be a correspondence that, all right, we supply, they supply, etc., etc. Lord, now kindly come to page 10. It is thus clear that even if there is a contractual document in existence between party A and B, as contemplated under section 7(4), I'm sorry, page 6, page 6. It is thus clear that even if there is a contractual document in existence between party A and party B, as contemplated under section 74A, if both of them have a defined legal relationship with entity C or D, qua the dispute, not, my lord, some other relationship. I am now, my lord, restricting to give a purposive meaning, my lord, and to ensure that it doesn't become an unruly horse where anybody and everybody is included. Qua the dispute, an arbitration would take place amongst A, B, C, and D, irrespective of as to whether A, B, C, or D are contractually connected with each other, or irrespective of whether C or D are signatories to the document contemplated under section 7(4)A. Well, this is the crux. So parties are not to be read as synonymous of signatories, and the existence of a defined legal relationship can be inferred from the correspondence also. Lord, kindly come to, ignore 14, come to 15. Lord. Section 7(4)B, however, makes above referred legislative intent more clear. It specifically does away with mandatory existence of a conventional document only to be regarded as an arbitration agreement. Under the scheme of 2H and 7, even exchange of letters, telex, so and so, is an arbitration agreement if it provides record of agreement based upon a legal relationship. Now, my lord, next is relevant, as my lord very succinctly, my lord, fell from my lord the Chief Justice of India, the subpara.
Yes.
Subpara. In other words, the term agreement, except as used in section 7(4)A, that is document signed by the parties, is used not in the conventional sense of a document of agreement with signatories, but as an act of agreement. This is, my lord, the heart and soul of section 7. Whether contractual, not contractual, if it gives rise to a defined legal relationship and there is a reflection of some act by even non-signatory agreeing to something by each and every mode, whether contractual or not, and may be between more parties, if all of them constitute a legal relationship in a transaction. This is how, my lord, the letter of section 7 will be infused with spirit and blood by your lordships by interpretation.
No, Mr. Mehta.
My lords.
See, the contract, the correspondence between A and B, and what they decide is, it is the C who will supply. But C is not a signatory, the example that you have taken. Now, unless there is a conduct in furtherance of the contract between A and B by C, you can't rope in C. There has to be a conduct.
Your lordships are right.
And the conduct is in furtherance of the contract between A and B, although C is not a signatory. So therefore, just the correspondence between A and B will not drag in C under the group of...
I bow down. Your lordships are right. The example which I would wish to give to buttress my argument would be this. What is essential is something should emerge to be a defined legal relationship. Number one. Number two, it need not be a document signed by two parties as an agreement. It can be exchange of letters. Now, in the same example which my lords were pleased to give, not suppose there is a correspondence between A, B, C, A to C, C to B, B to A, and if it can be found out that because of this correspondence, though the arbitration clause is only between A and B, but C has also participated. He was a part of the negotiation process. He also given certain assurances, etc. Then C cannot say that I am not a signatory to the contract between A and B, and therefore I cannot be a part.
Therefore, in this example, really speaking, there's a predefined relationship, pre-existing relationship between A and C when A agreed to
Or B and C for that matter.
Yeah. A, B, and C, Mr. You are A or you are C. Mr. Khambata is A and Mr. Diwan is B.
Correct.
So when A agreed to supply goods to B, and there is obviously in your example, there is exchange of correspondence, there is an exchange of emails, there is an exchange of communication between C and A and B, and by which C also is intrinsically a part of either the negotiations or the performance or the execution of the contract. These cases may not be that difficult. Question will arise where C has completely stood separately and away from the contract.
Bystander.
He's a bystander. But there is a pre-existing relationship between A and C, which is what you, I'll just go back to your, the way you have formulated it at page 7. A, an agreement, arbitration agreement as understood under the Act is not a conventional agreement only. Fair enough. An arbitration agreement can take place whenever certain disputes arise among entities when such entities have a defined legal relationship.
That is must.
That is your relationship with C's relationship with A. Then C.
No, with the dispute.
With the dispute.
No, exist not with the parties. Existence of a defined legal relationship was a dispute.
With the dispute.
Was a contract, I would say, was a contract.
We'll add in B then. Have a defined legal relationship with the dispute or the contract.
Or contract. I may not be a signatory to the contract, but I have from the exchange of correspondence by some action. For example, my lord.
So long as we say quay the contract, I think then it becomes a little more structured.
Yes.
Once we add quay the contract.
Correct, my lord. For example, there is a tender floated by Mr. Diwan, and my learned friend Mr. Khambata is participating, where there is a requirement that some company having more than 500 crores turnover will stand as a guarantor so that he can supply the goods to him. I am that company. I stand as a guarantor, and there is an exchange of correspondence. Then it will be, my lord, a fact-specific determination. But I cannot say that because I am not a signatory to your contract, I am out of it. If there is a defined legal relationship emerging from our actions, because therefore the legislature says contractual or not, there can be a defined relationship without entering into a formal contract.
So how does this relationship come in? By your agreeing to be the guarantor in the contract between A and B. So therefore you have entered into, or you have acted in a manner which has furthered the contract. So you can't be saying that I am a bystander there.
Therefore, you can't be saying in that case that, look, I'm not a formal party to the arbitration agreement, which was a contract between A and B, which contains the arbitration agreement.
For example,
ultimately, Mr. Mehta, therefore, it boils down to how you will interpret that particular fact situation.
Exactly. It will
really should not be laying down
fact-specific determination.
It should not be laying down extremely rigid or tightly controlled.
Cannot be and should not be. That's my respectful support.
Then it will be very dangerous.
Yes. Well, that cannot be, and that's what I have said, that it will have to be a fact-specific determination. Suppose a Chinese company has a local Indian company as its subsidiary and is entering into contract with local Indian other companies or other individuals, and the Chinese company agree that yes, we are behind it, we are a financially sound company, you can enter into this relationship, and there is an exchange of correspondence, which gives rise to a defined legal relationship. Its relationship is not that of a mortgage, that of a guarantor. The legislature doesn't use a particular kind of defined legal relationship. Any defined legal relationship,
whether contractual or not.
Contractual or not. So that's my respectful submission.